Good evening, everyone, and thank you for joining us for this evening's seminar. Before I introduce our speakers and the seminar itself, I want to start by sharing some very sad news, which was the sudden death of one of our Chamber's colleagues, Heather Rogers KC, at her home yesterday. For anyone who's on the seminar tonight and knew Heather and would like to send a message of condolence, there's a link on Chamber's website. I also want to take a moment to recognise the impact of the events in Israel and Gaza, which we've all witnessed unfolding in the last 12 days, and to take a moment to mark the horror and grief which we all feel at the lives lost and the suffering caused. I'm going to ask you all to join the panel in a minute's silence on behalf of all those affected by the conflict and those in particular who suffered recent loss. Thank you. I'm going to introduce our first speakers shortly, but before I do that, I want to start with a bit of housekeeping. This session is due to run until 7 o'clock, and what we've got is 3 talks given by our panel members, and there'll be time for Q&A at the end. So if you can hold any questions back or put them in the chat while our speakers are speaking, and we'll come to the questions collectively at the end. All right. And just wanted to start by talking a little bit about this seminar. So this is one of a session in a series that's been organised by the Migrant Rights team here at Doughty Street. And previous sessions have addressed unaccompanied minors and care leavers, the position of Afghan and Ukrainian citizens in the UK, and asylum support. And in each seminar, we've been addressing themes within migrant rights in a way which combines perspectives both from legal practitioners and also from frontline organisations. So this session is going to look at challenges to accessing support for migrants who are subject to a no recourse to public funds condition, the impact of the hostile environment, and the challenges posed by recent legislation, including the Legal Migration Act. We have an excellent panel for this evening's seminar, and our first speakers are Kaz Hattam and Rupinder Pahar of the Unity Project. The Unity Project is a small charity whose volunteers meet on a weekly basis to support people to apply for access to public funds through a change of conditions application. The Unity Project focuses exclusively on this application in its casework. And with the evidence and insights it's gathered through this casework, the project has supported over half a dozen successful legal challenges to the policy. Rupinder is a trustee of the Unity Project, and she has over a decade of experience in policy influence, advocacy, research, grant funding and programme design on issues including migration, Nrpf, and access to justice and equalities within the voluntary sector and in local government. Kaz is a co-founder of the Unity Project in 2017, and she manages the project's casework, and she's going to be speaking more about the challenges which the project has run. So without further ado, I'm going to hand over to Kaz and Rupinder for their speech. Thank you.
Thank you. So I think I'm starting. So I'm just going to run through the sort of context around no recourse to public funds, and then Kaz is going to speak specifically to the work that Unity Project does, including some of the recent litigation. Am I able to control this? No. Am I going to have to ask someone to just, sorry, move to the next slide? So yeah, I'm just going to run through sort of context of the no recourse to public funds condition for those that don't know. So in terms of being formalised in the law, that was initially done through the Immigration Act of 1971. However, access or restricted access to welfare support for those with insecure immigration status has existed well beyond that. Effectively, from the introduction of immigration controls, it's always been contingent on non-UK nationals not being able to access welfare, and that's charted back as early as the early 1900s, and actually well before that as well, with the kind of refugee kind of resettlement in the country. But the kind of formalization of it happens in immigration legislation from 1971. If you look to section 115 of the Immigration and Asylum Act of 99, that just maps out who is impacted by no recourse to public funds, and also lists what counts as a public fund. And this is a really important point, because I think very often there's an assumption made that everything comes under the banner of public funds. However, there are some restrictions on things that you are still able to access. So most welfare benefits do count as a public fund for the purpose of immigration. And it comes under the Home Office guidance as well as being listed in the legislation. It also includes access to housing assistance from a local authority, as well as allocation of social housing. So all of those are restricted. However, the sorts of benefits that you can still access include contribution-based welfare benefits, as well as some statutory welfare. So I've listed some there, but there's a more comprehensive list available on the government website. So things such as statutory sick pay, maternity allowance, state pension, etc., you would still be able to access even if you are subject to the no recourse to public funds condition. Can we go to the next slide, please? So in terms of who's affected, most visa routes now would be impacted by the no recourse to public funds condition. So those that have leave to enter or remain under various routes, as well as those who are seeking asylum. Of course, there's a parallel welfare system for those that are subject to, that have made an asylum claim, as well as those that are appeal rights exhausted. And also people that are undocumented would de facto have no recourse to public funds because they don't have a legal status. And just to say, in terms of the expansion of specifically the 10-year route, so the family migration routes, which were expanded from 2012, where that kind of the change in the immigration rules at that point meant that there was more of a wholesale application of the Nrpf condition onto visa routes. And it was also the point at which a change of conditions application, the possibility of being able to change your conditions to remove the Nrpf condition from your leave, was also applied. So at a parallel time that there was basically more wide sweeping controls to who can access welfare support, there was also this kind of contingency allowed, this ability to access welfare through this formal legal route, which Kaz will go on to. Can I go to the next slide? Thank you. So just really quickly, I wanted to run through some of the kind of network of support that is available to people that have no recourse to public funds. If you want to find out more about rights and entitlements, I'd recommend looking at the Nrpf network website. So they're based within Islington Council and have quite helpful guides on rights and entitlements, and as well as kind of summaries of relevant legal action around chipping away at the impacts of Nrpf. So for children and families, so if you've got a family that is destitute, that is homeless, that needs access to financial support, perhaps parents don't have immigration status and they may be in the process of trying to resolve that, or even where they do have leave to remain, if they're found under Section 17 of the Children Act of 89, basically the child has subsistence needs, and as far as is it's safe and possible for them to remain with their family, the local authority has got a duty to support parents as well as children in a family with housing support, subsistence, etc. So usually that would take the form of some basic subsistence payments, which aren't standardized across the board, and there were efforts to kind of standardize that through the 2016 Immigration Act measures, which weren't brought into place. So yeah, it's quite ad hoc in terms of what you would get from a local authority, and the possibility of being placed in temporary accommodation, which can be, quite basic bed and breakfast provision for long periods of time, which are often quite unsettling and often not appropriate for children's needs. But the point is that there is recourse to support through local authority, even if parents don't have immigration status themselves, through Children's Services team. Unfortunately, very often what you will see is there is a lot of gatekeeping that advocacy organisations and those that work with families encounter. So where a local authority may say, yes, we'll support the child, but we'll put that child into care. We don't have a duty towards the parent, or unfortunately, in more punitive cases, offering parents return to their country of origin and, saying that they'll keep the children in Britain because they may be British or at least have entitlement to remain in Britain. All of these things usually tend not to be accurate advice, and you can go to advocacy organisations to get support on that. And obviously, there's many routes into making sure that local authorities are fulfilling their duties to support families and children. And then in terms of single adults, where they have particularly high care needs, there are provisions within the Care Act. But these, it can be quite difficult to get this support. Often people's needs need to be quite high. There's a lot of kind of variance, I guess, in terms of the support you can actually get through Care Act assessment, but there is a possibility of it. So again, if support is being refused to somebody that has particularly high care needs, there is at least something in legislation that enables access to that. For survivors of domestic violence, this is normally specifically for those that are on spousal visas or partner visas. There has been litigation on this over the years to try and expand who it applies to, because as we know, there's quite a restrictive group of people that tend to be on spousal visas, particularly with the income threshold and changes like that being brought in over the years. But where the relationship breaks down because of domestic violence, initially you can apply for indefinite leave to remain through set DV application. So that's the immigration application. And then for those that are at the risk of destitution, you're also possibly able to apply for a destitution domestic violence concession. This would enable, if you're granted it as somebody on a spousal visa, ability to access welfare benefits, usually for around 3 months. So that would support someone to get into a refuge if they need it, or to pay for rent to stay somewhere, as well as access to welfare benefits. And also, if they make sure to put in an application, an immigration application under the set DV route within that time, they should still get continuing 3C leave. So that would also mean that they have, they would continue to get support under the DDV concession if they make sure to apply within that 3-month period. It is really important to stress that this is for people that are at risk of facing destitution. Sometimes you see cases of people applying under this route where they're not actually kind of destitute, and actually it's not appropriate in that case. Thank you. So this is just kind of summarising. There's quite scant data available on people that are impacted by no recourse public funds on a national level. However, there are some kind of relevant sources you can look to if you're kind of interested in building a picture of how this plays out in your area. So the Nrpf Connect database is run by the Nrpf network in Islington Council. So of all the councils that specifically have dedicated teams, particularly within usually children and adult social care, that work with Nrpf cases, they try to collect the data of how many families and individuals they're supporting, what the cost is of supporting them, how long they're ending up on that support. Very often you might encounter perhaps a family's been on Section 17 support and they put in an application under the 10-year route for leave to remain. They get their grant of leave. It's once that initial grant expires, even if they've had access to public funds, there's a risk that they get put back onto the Nrpf condition is reapplied, and then they go back into local authority support in the time that they're then reapplying or trying to have the Nrpf condition removed. So yeah, it's a helpful database for building a picture of the way that that's playing out regionally as well as across London in different boroughs. There is some Home Office data on the change of conditions applications, which Kaz is going to speak to, usually just the sort of numbers of people applying and some kind of basic data around grants and nationality, etc. But there isn't significant other data that the Home Office currently provides around grants of no recourse to public funds for people across different visa routes. And just to say, there is some upcoming research coming from the Migration Observatory, so a briefing specifically on the impact of no recourse to public funds. and some kind of estimated numbers. And there have been attempts to, kind of in social policy research to kind of build a picture of the number of people nationally that may be impacted by NRPF. However, it's difficult because you're talking about people that have both leave to remain as well as people that are undocumented. And particularly with the latter group, it's inherently difficult to build a picture of people that do not have visas currently because of the nature of not, agencies and Home Office, etc., not having contact with those people and them not being represented on databases, etc. So we know significant numbers of people are still affected by it. Obviously, a lot of people that have visas do have the condition applied, but of course, vast numbers of those people will not need to access welfare benefits unless they befall a particular crisis. But yeah, just kind of as a sort of overview, what numbers are available. Can we move to the next slide, please? Thank you. And just I wanted to wrap up with there is ongoing campaigning across civil society and actually also in many cases kind of mirrored within local government to abolish the NRPF condition because of the various complications that it creates for individuals as well as support agencies and statutory organisations. So obviously the NRPF condition traps people in destitution, particularly those, some people that are amongst the worst impacted by being in poor work and then potentially losing that work, low pay, etc. So we're not just talking about people that are without work, but very often also people that are facing in-work poverty that still continue to need access to welfare benefits to top up the subsistence that they have access to. The NRPF condition also creates a disproportionate cost burden for local authorities, and this is something that local government organisations have tried to highlight the cost of, certainly over the last decade. It is significant, particularly in London boroughs, where local authorities are effectively a first port of call for many communities and providing a sort of shadow welfare benefit network in the absence of the welfare benefit, the state being able to offer that support. So this creates huge cost burdens for local authorities, and it's in the interests of not only kind of individuals and VCS organisations, but also local government that central government enables people to actually just access support by removing the NRPF condition from people's leave. So yeah, there have been joint calls across civil society, local government, legal advocates, etc., to actually abolish the NRPF condition and enable access to the welfare system. Of course, this doesn't mean that people would magically be able to access the many, many fruits of the obviously bountiful welfare system that we currently have. There are already checks in place when it comes to accessing welfare support, as many of us know. So this will just remove that additional barrier to accessing welfare support for individuals, and those campaigns are ongoing. So yeah, that's just it for me in terms of setting the scene and the context.
Thanks, Rupinder. So as you've heard, we focus in our casework exclusively on making change of conditions applications. I'm actually not, just because of limited time, going to go into a huge amount of detail about that process, but did want to say that if any of you are making these applications or would like to make these applications, we would always be very happy to speak more about that, provide more formal training, or have more informal communication about change of conditions applications that you are working on. But what we have done through our casework, because we're making so many change of conditions applications, that has allowed us to build up quite a big evidence base showing the different impacts, and we're able to have quite an insight into trends and issues that are coming up for people who are trying to make change of conditions applications, which has meant that we can support legal challenges to the policy more broadly, and that's what I want to focus on. Just a caveat that I'm not a lawyer. We work very closely with Dayton Pearce Glynn, particularly Adam Hunt, so I hope this is of interest to lawyers and non-lawyers. But yeah, I'm going to go through a bit of kind of the history of the various legal challenges that we've been involved in. And I guess I want to focus especially on what's changed as a result of that litigation, and also what's not yet changed, what's still the same, because it's a question we're constantly thinking about, is how is it there have been so many legal challenges and the policy still exists, and many of the challenges that we were facing when we first started in 2017 are still there. So I guess that's just a question for us all to be thinking about. But if we can go on to the next slide, and next slide, thank you. Next slide. Perfect, yeah. So we're going to start in 2014. This was the first successful challenge to the policy. This was before the Unity Project existed. This was brought by DPG. And this challenge basically resulted in the change of conditions application process coming about. And it also resulted in the Home Office publishing a policy equality statement in relation to the Nrpf policy. And then next slide. It was then a few years before the policy was challenged again. This was after we had been making change of conditions applications for about 18 months. And the policy was again challenged. This case didn't actually get to court, but the result of the settlement was that the Home Office reviewed the policy in compliance with the public sector equality duty. They published this review, they consulted about it, and that resulted in the publication of a new kind of updated policy equality statement in 2020. And then next slide. Was the following year, the policy was challenged successfully again. This time it was on the grounds that it didn't prevent inhuman and degrading treatment. And that was because at that point, people could only make a change of conditions applications if they were already destitute. And what this litigation resulted in is that the policy guidance initially and then eventually the immigration rules were updated to say that people could apply for access to public funds before they became destitute, if they were at risk of destitution. Next slide. And then the following year, another legal challenge. This time, the policy was ruled unlawful again, and the relevant immigration rule, because it didn't adequately safeguard and promote the welfare of children. So it's about Section 55, and as a result, the immigration rules were updated again, and the policy guidance was updated again. And at the end, I'll just look briefly. We'll look at the previous immigration rules and as they are now, so we can kind of see over the course of these various cases how the immigration rules have changed. Next slide. So again, this didn't actually go to court, but I just wanted to mention another change in the policy that happened in 2022. Prior to this, if you were on the 5-year route to settlement and you made a change of conditions application, if you asked for access to public funds, you may have been granted it, but you would be automatically switched onto the 10-year route to settlement. So you'd have to wait twice as long before you could apply for settlement and pay twice as much in immigration fees. So in February 2022, the government announced that the policy that policy would be on hold pending review. And a few years later, actually fairly recently, the policy was officially updated. As you can see where I've highlighted there. So you now will no longer automatically be switched onto the 10-year route if you apply for access to public funds. You can have access to public funds and remain on the 5-year route to settlement. The next slide was another challenge in the same year in 2022. And this was another challenge based on how the policy impacts children, to say that despite the immigration rules and policy guidance being updated, the policy was it was still unlawful in terms of how applications were being processed in respect of applicants who had children. And then next slide. And then in 2023, earlier this year, another legal challenge was successful, to say that the immigration rules and the guidance again were unlawful because they didn't adequately instruct caseworkers about how to deal with applications that raised exceptional circumstances or disabilities. And so again, the immigration rules and the policy guidance have been updated to reflect this ruling. And finally, recently, so this judgment was published 2 weeks ago, actually slightly less than 2 weeks ago. And so the outcome and what will come out of this is obviously this is still very new, but the High Court ruled or kind of explicitly made it clear that the Home Office has discretion to remove the Nrpf condition from any leave to remain. So previously, as many of you will know, you could only make a change of conditions application and apply for access to public funds if you had leave to remain on a human rights ground or as a B&O visa holder. This made explicit that anybody can apply, the Home Office has discretion to remove the Nrpf condition from any visa. The immediate outcomes of that are that with the judgment, the judgment has published an OPI, which makes this very clear, and the Public Funds caseworker guidance has also been updated to make this discretion very clear to applicants and caseworkers. But we did want to note that risks and complexities are still going to exist for people who are on, for example, student visas or skilled worker visas. And that might become clearer with the next slide, where I've just quoted the bit of the policy guidance that's been updated following this judgment. So you can see with the bits that I've highlighted, it makes clear that there is this discretion to vary the conditions and remove Nrpf from any type of visa. But then you'll also see there are various considerations that caseworkers are prompted to take into account. And the major thing is whether somebody can reasonably be expected to return to their home country. And the policy guidance also makes very clear that these circumstances will have to be particularly compelling. So we're still kind of, as an organisation, working out how we can assist people in light of this judgment, and I'd be interested if this comes up in our discussion as well. Finally, I just wanted to kind of sum up what's changed in the rules, because I think we and the Home Office caseworkers are often kind of guilty of being stuck in the past in terms of who used to be eligible to make a change of conditions application. So the immigration rules that used to exist are on the left, and you can see that people could apply if they were destitute, and then there was a kind of convoluted description of what how the welfare of children would be taken into account. On the right is now the updated immigration rules following all of this litigation. So destitution is still there, but people can very clearly apply if they are at risk of imminent destitution. Welfare of children can be taken into account in a much broader way. And then thirdly, there's now a reference to exceptional circumstances. So I wanted to highlight what has changed and the scope that then gives people and advisors to make applications for access to public funds. And I guess I just wanted to finish as well to say that despite these changes, there's still a lot that can be done. And I guess just a couple of those things that I guess we wanted to highlight. And I guess the reason that we wanted as well to be here is because there is a lack of knowledge about the fact that people can apply for access to public funds, and the fact that support is available to people to make applications for access to public funds. Yeah, I think I'm going to end there because we're out of time, but thank you very much.
Thanks very much, Kaz and Rupinder. Our next talk is from Shushin Liu, who's a barrister here in the Migrant Rights team here at Doughty Street. Shushin will be familiar to many of you, I've no doubt. She has a stellar practice in public law and particular expertise in migrant and asylum support issues. Recent high-profile cases in which she's been involved include the successful and I think ongoing judicial review on behalf of ECPAT UK in a challenge to Kent Council's use of hotel accommodation for asylum-seeking children. And she's also been recently involved in the Brook House inquiry. Shushin is going to be looking at the impact of the hostile environment and misuse of government powers and the impact on migrant support. Shushin.
Thank you, Leonie. I was trying to think of a unifying way to cover three themes that I wanted to cover today. And I think the best way to put it is the overreach of the hostile environment measures. Next slide, please. So three topics that I wanted to cover was the misuse of detention examination powers on people with lawful residence, so people who have now been granted limited leave to remain, but have NHS debt. And then the second topic is the denial of care to unaccompanied asylum-seeking children and the differential treatment as compared to British children or resident children. And the third is a sort of look at the undocumented migrants, so people who have lawful immigration status but are undocumented, which obviously was a key issue in the Windrush scandal. But post-Windrush, are there other cohorts in a similar position? And I wanted to flag some litigation that's ongoing on that. Next slide, please. Next slide. So in relation to the misuse of detention and examination powers and NHS charging, some of you may be familiar, there's been a High Court case on this called MXK and SXB, but I just wanted to give some context to this for those of you who might not be familiar with the issues. In principle, there is a power to detain someone on arrival into the UK, if it's necessary to do so, to examine whether or not to grant them leave to enter or to refuse them leave to enter, or alternatively, if they have leave to enter, to either curtail their leave or cancel their leave. And the other context of this is NHS charging, obviously. NHS charging is apply to anyone who's not ordinarily resident. This can be, you know, people who have British nationality if they have predominantly resided abroad. But for the main cohort, it is the people who don't have leave to remain. And I've put the relevant provisions there. I mean, there obviously are certain treatments that are exempted, like for FGM, for treatment related to torture, domestic and sexual violence. And then there are certain people who are exempted, including asylum seekers, looked after children but not care leavers, and people who have paid the immigration health surcharge or the surcharge is waived. If you are someone who has accrued debt, of over £500 post 2016, it used to be £1,000 pre 2016, and it's unpaid for 2 months, then it gets reported to the Home Office and can form a discretionary ground for refusing you leave. Next slide, please. Now, the claimants in these cases are women who have leave to remain now, but who were charged for maternity care at a time when they had no leave to remain. And obviously they were subject to the discretion ground for refusal of leave because of their NHS, but the Home Office made an express decision in these cases not to exercise that discretion to refuse them leave, but to grant them leave instead. And what is important in this context is NHS debt, although can be a ground to refuse you leave, it can't be a ground to cancel your existing leave or to curtail your existing leave. And this becomes important in this context in terms of the exercise of examination powers and detention powers at port. MXK had leave until since 2013, but every time she entered the UK after visiting family or going on holiday, she got stopped and detained. SXB had a similar experience. Both of them were detained and put in those holding areas. I'm sure all of you, when you've gone through airports, you will see this holding area. That's a detention area. And not only were they detained there, they were detained but with their children. And we had put together lots of case studies, and over 30 case studies of other people with leave to remain, and mostly women who have NHS debts, who were also stopped and detained for examination about their NHS debt. And the detentions were lasting for up to 5 to 6 hours. Next slide, please. What we found in the course of this, and part of this work came out of work with Maternity Action and other organisations to challenge the scope and reach of NHS charging, but in the course of that discovered that quite a lot of women who were charged and then got leave to remain, mostly under Appendix FM and Family Life, were being stopped in this way. and litigation in both MXB and SXB and previous cases, there was a case called JTW, uncovered that the Secretary of State actually had a secret policy of using examination powers and detention powers under the Immigration Act to stop and detain anyone who has lawful leave but has NHS debts. And the basis of that policy was that they needed to be detained and examined so that they could get updated information about their whereabouts, so that they could find out the progress of the payment of the NHS debt, and to encourage, or rather put pressure on them to repay their debts. And the grounds of challenge were that this was a total misuse of Schedule 2 powers, because the power to detain was parasitic on there being an ability to detain you for examination. But the examination power was limited by purpose to, can I curtail your leave or can I cancel your leave? And the Secretary of State accepted that you can't cancel or curtail leave on grounds of NHS debt, but sought to justify it because they thought, well, you might have other stuff that has happened in your immigration history that might require us to examine you. The second ground is the detention. So the argument is that, well, actually, the exercise of the examination power and therefore the detention power exceeded its purpose and limit. Detention was also challenged as being unlawful because of an unlawful and unpublished policy. And then there was also a breach of the public sector equality duty. This being important because in the context of the Windrush scandal, the Secretary of State was directed by the Equality and Human Rights Commission to conduct equality impact assessments of the hostile environment measures, and it's called a compliant environment assessment, but we all know what it actually is. But what it uncovered when it was published last year was that women were disproportionately affected by NHS charging. Hardly surprising, because they're the ones who need pregnancy-related treatment. Next slide, please. So I've dealt with the uncovering of this secret policy. And what also we uncovered was that actually, once you have NHS debt and you make an immigration application, a warning flag is flagged in the system in your file. And so what happens when you scan your passport at the border, that flag comes up. The problem is that flag comes up and it doesn't tell the border force officer at the front desk of border control what the flag is about. So they don't know that it's NHS debt. It could be national security, it could be some other thing. And so they have to go to the back office to check this. And inevitably, this will take time, and inevitably, this will have to result in detention. And what happened in that case was that the court decided that actually, okay, well, fine, you can do the checks on your warning flags, because we didn't challenge the actual warning index flags, because we didn't actually know about it until a week before the hearing that they existed. But even though you can check the flags, it's obvious once you have checked the flags that this is not someone you can detain. And so any detention beyond that check would become unlawful. And so that's what the court found, and also found that the Secretary of State acted unlawfully in having a secret policy that's unpublished. Next slide, please. But what remains unanswered is how far the reach is of this warning index system. And in particular, a secondary argument that was raised in this context was whether, generally speaking, the exercise of Schedule 2 powers is actually not in accordance with the law and not prescribed by law, contrary to Articles 5 and 8 of the ECHR. It's a suspicionless power, so you don't have to have reasonable belief that you could curtail or cancel in order to actually use the power. But there's a long line of both domestic case law and Strasbourg case law to say, well, if it's an unfettered power on the face of it, then it's got to be accompanied by safeguards against arbitrary and discriminatory interference with ECHR rights. And I've set out there, I think these slides are going to be circulated, I set out there the safeguards that the case law had identified. And the argument goes that, well, there aren't these safeguards in this context, and therefore the exercise of Schedule 2 powers is not in accordance with law. The court didn't feel it was necessary to deal with this point because we had already succeeded on the policy challenge and the exercise of Schedule 2 powers being beyond scope for NHS debtors. So that remains a residual issue. Next slide, please. Right, so very quickly, because time always escapes us in these cases, I wanted to just briefly touch on the denial of care to unaccompanied asylum-seeking children, a topic that most likely people will be very familiar with already from the ECPAT UK judgment. When these slides get circulated, you will see the chronology of events that developed leading up to the challenge in early 2023 and judgment in July 2023. But the long and short of it is, at some point in August 2020, Kent decided, that's enough. We're at capacity. We can no longer take any newly arrived unaccompanied asylum-seeking children into our care. So we're just going to close our doors unilaterally. And part of their complaint is that the national transfer scheme didn't function properly, so that they could transfer some of the responsibility from them to a receiving local authority through the scheme. The Secretary of State responded in July 2021 by starting to use hotels to accommodate unaccompanied asylum-seeking children. Next slide, please. The challenge, it's not hard to see why this is problematic legally, factually, and just morally. But Kent has clear obligations under the Children Act to take care of unaccompanied asylum-seeking children who don't have parents and don't have any other way of looking after themselves. And the Secretary of State doesn't have a general power to use hotels as a routine basis to house children outside the care system. But in the course of this litigation, we also uncovered that actually Kent and the Secretary of State had made an agreement in September 2021 so that they would essentially, part of the agreement was to fund Kent to look after unaccompanied children. But in the course of that arrangement, there was also an agreement that Kent would have a cap on the number of unaccompanied children that they would be responsible for. Again, it's not hard to see why that would be unlawful. Next slide, please. And certainly that was what the court found. And perhaps I just wanted to bring everyone up to date as to where things stand now. There have been various declarations and orders, as you can see, declarations that Kent has acted unlawfully under the Children Act, quashing of the cap, quashing of the NTS protocol because of the use of hotels to house unaccompanied children by the Secretary of State, and various interim orders. And then now this is actually quite interesting because the interim orders are made on the proviso that the two quashing in the bullet points was suspended for a period of time so that Kent and the Home Secretary could get their ducks in a row, essentially, to try and bring the illegality to an end and restore normal lawful actions. Obviously, we've had 3 hearings now, and the Secretary of State and Kent have been given 3 opportunities to do that, and surprise, surprise, it's still not fixed. So there is due to be a further hearing in the end of November, December, at which point the court had made a very strong indication on the last occasion that he's going to, Mr. Justice Chamberlain is going to make an order prohibiting the use of hotels. Quite then what next in terms of how then to get Kent to say, okay, fine, we'll now take all the children, when their entire mantra is, well, it's not safe for us to do so, and therefore we're not going to do it. Next slide, please. I have set out some thoughts as to, well, what are the consequences and what still remains unanswered, even if the various further declarations and orders are made on the next occasion. And that is in relation to the rights of individual unaccompanied children who are affected, who may have public law remedies for being taken out of the care system, for now having turned 18 and having had no local authority care. Those who may have been discriminated against, because one of the issues that is indicated by the judge is the treatment of newly arrived unaccompanied children differently to resident children, because Kent wasn't refusing to care for resident children, may amount to discrimination. So those are issues that remain to be resolved, and obviously Adam's going to touch on the Illegal Migration Act, so I just wanted to flag the two provisions that may also be impacting on this in the future. I'm going to do a whistle tour of the next slide, next two slides. So this, everybody knows about the hostile environment, I don't need to repeat that. But obviously the Windrush scandal related to people who are actually lawfully in the UK, lawfully entitled to rights to services, right to housing, rights to work, but were unable to do so and were treated as not entitled to it because they couldn't document and demonstrate their lawful status. Next slide. Now, the issue of status and how you prove your immigration status, because that is so important for the hostile environment, it's entirely premised on, can you show that you have permission to be here? If so, yes, you can rent, yes, you can work, yes, you can get benefits. If you can't show it, then, well, I don't care really if you actually have lawful residence. Now, the form of lawful residence proof was challenged firstly in 3 million, which is all about digitalization of immigration status. But really the thing that I wanted to focus on was the Section 3C category of people. That is the people who have lawful leave to remain, who make an in-time application to extend their leave to remain. So their BRP, the bioresidence permit, will have expired, but they actually have the same conditions and same entitlements as that leave, whilst the Home Office is looking at their extension application. This cohort of people, very similar to the Windrush cohort, don't have any documents during the period of time that they are considered, their application for further leave is being considered. Next slide. Ramphel did a very detailed report on the impact of this, and you can see from the 3 bullet points, just broadly speaking, that it's very clear that people who don't get documents but who have lawful leave are caught up in the hostile environment, are denied access to employment, have their jobs suspended, benefits suspended, student finance denied, etc. Next slide. This is currently being challenged by Ramphel and by an individual claimant on the basis that the Secretary of State has failed to provide effective means for people with Section 3C leave to demonstrate their ongoing lawful immigration status and their rights, and that the failure to do so was contrary to the statutory purpose of Section 3C, which its intention is to protect the immigration status of people whose application for immigration leave, further leave is pending, and who did so following all the immigration rules of applying in time. And it's also, we say, a breach of the purpose of hostile environment measures, because this is not the category of people intended for the hostile environment measures. They have lawful residence. They're not the people that the Secretary of State was trying to force out of this country by making the environment so hostile for them. And the other ground of challenge is irrationality, that it's irrational to not provide this category of people documents. And then also there's a PSCD argument because there hasn't actually been a proper audit of the impact of hostile environment on undocumented migrants beyond the Windrush category. Permission has been granted in the case, and the hearing is due at the end of 2023, early 2024. So this is sort of yeah, so that's all I have to say. But it's just to show that beyond the sort of traditional categories that we oftentimes work with in terms of migrant rights, that even when you get lawful residence, it can still you can still be a second-class citizen. You can still struggle with the hostile environment. Thank you very much.
Thank you, Shushin. Before I introduce our last speaker, just a quick reminder to you all that you can put any questions you have for the panelists into the chat box and our panel can address them at the end. If you'd rather ask anonymously, just send it direct to me and then I'll ask on your behalf. Our last speaker is going to be Adam Straw-Casey, who's part of the Migrant Rights team here at Doughty Street. Adam will also be familiar to many of you, I've no doubt, and he has extensive experience in public law, human rights and equality law. Recently, he's been acting for the Northern Ireland Human Rights Commission in a judicial review challenge to the Illegal Migration Act, which has been granted permission. He's also acted in a number of cases concerning access to Section 95 asylum support and accommodation, particularly for Afghan nationals, and in other welfare benefits cases, including Kay and the Secretary of State for Work and Pensions, which was a challenge to policy on overpayments of benefits. Adam's going to speak about the impact of the Illegal Migration Act and recent changes to the HMO licensing system and how those affect migrant and asylum seeker support. Adam.
Great. Thanks very much, Leonie. Good afternoon, good evening, everyone. As Leonie said, I'm going to look at a couple of new pieces of legislation, two of the government's wholesale attacks on asylum seekers. But I'm going to start with just a little bit of background, put it in context. And Section 95 of the Immigration and Asylum Act 1999, and a few cases amongst the raft, really, of recent case law about Section 95. So just as a reminder, Section 95 of the 1999 Act contains a power which is actually now a duty for the Secretary of State to arrange for the provision of support to asylum seekers and their dependents if they appear to be destitute or are likely to become destitute. Now, the three recent cases I'd like to look at are in paragraph 5 of my notes. They're summarised in paragraph 5 of my notes. Those notes hopefully would have come over to you, and if not, they'll be available after the seminar. But the three recent cases are quite interesting on just different aspects of Section 95. So the first of them is HA against the Secretary of State for the Home Department. And this concerned pregnant women and children aged under 3. And two of the interesting findings from that case was follows. The first of them was that the support that's required by regulations 10 and 10A of the 2000 asylum support regulations had to be provided in cash. So there was no general option for the Secretary of State to provide those that support in kind. And the Secretary of State had made the argument that, well, we can provide this in any means we want, and it's not necessarily to produce cash, and that was rejected. The case is quite a helpful guide if you have pregnant women and children under the age of 3. It's a quite helpful guide of the background to that. And they also, the court also held that there's an obligation to make a determination of Section 95 claims promptly. And in most cases, that's within 10 days. And the provision, if it's a positive determination, then the provision needs to begin immediately. I mean, if there's any significant time between the Section 95 application and the decision, then Section 98 of that Act needs to be used in order to provide temporary support. CB is the second case I'd like to just briefly summarise. This reiterated the fact that there is a duty on the Secretary of State to carefully investigate what amount of money is necessary in order to meet the various categories of essential living needs within Section 95, and a duty not only to investigate that on an ongoing basis, but also to make a decision as to what level of support is necessary. Now, there was no decision in 2022 at all by the Secretary of State, and that was notwithstanding the fact that there was a really obvious change in circumstances which made a decision really important, which was inflation at 10.1%. And the High Court said that the failure to make a decision was unlawful as being an abdication of that function, so the function of continuing to investigate and decide what essential living needs were, and also a failure to take into account relevant matters, the 10.1% inflation being an obvious example. SA is the third case I've got in my notes. And this was an interesting case identifying, as a number of other recent cases have done, a breach by the Secretary of State of the Section 95 duty. And the claimants were in hotel accommodation, and the court found that there was a failure to meet the objective minimum standard by failing to secure a dignified standard of living which was adequate for the family's health and capable of ensuring their subsistence. So that's the general test that's being applied. The facts were the claimant was pregnant and vulnerable. Secondly, there were breaches of the vulnerability policy. So if you have someone who's vulnerable in these circumstances, it's worth looking at that policy and making sure that it's been followed properly. The fact that there have been breaches of it was relevant to the finding of unlawfulness. The claimants have been in hotel accommodation for 15 months. That was also a significant factor. And then the fourth reason for the decision is something which may apply more broadly. There was a lack of record keeping to demonstrate that the decision makers had actually thought about the issue. And the court held that that's relevant to the finding of unreasonableness, of unlawfulness. So if you have a case and the defendants just don't have any evidence of them actually going through the thought process, whether in Section 95 or otherwise, then that can be part of your claim. That can be a ground to show an aspect of your argument that the decision was unreasonable. So that's the case law. Then just continuing with a little bit of the background before coming to the Illegal Migration Act, we've looked at Section 95, Section 4 of the Immigration and Asylum Act 1999 allows for the provision of support to failed asylum seekers. So people who can no longer qualify under Section 95 because they're no longer asylum seekers, but only if they are both destitute and also they satisfy one of the conditions in the 2005 provision of accommodation regulations. Those conditions are all set out in my notes, but there's one that's going to be particularly important under the Illegal Migration Act, which is condition C, which is that the individual is unable to leave the United Kingdom because, in the opinion of the Secretary of State, there's currently no viable route of return available. Now, one of the key problems with the Illegal Migration Act is that for a large class of people, it both prevents them claiming asylum, making any protection claim in the UK. It contains a duty to remove them, but it also, for a large class of them, will make it impossible to remove them. So it will mean there'll be a very large group of people who can't make a claim here, have to be removed, but can't be removed. And so I think this provision will become particularly important. So as I've said, Section 4 and 94 Sections 4 and 95 show the juxtaposition between an asylum seeker and a failed asylum seeker and give different provisions of support. Now, that's a really important distinction under the new Act. And that's because the Illegal Migration Act amends the circumstances in which someone is considered to be a failed asylum seeker as opposed to an asylum seeker. And it does that in two ways. The first of them is that someone whose claim is inadmissible under the Illegal Migration Act will amount to a failed asylum seeker. And those circumstances are extremely broad. So the first thing that has to be shown for someone's claim to be inadmissible are that they meet the conditions in Section 2 of the Illegal Migration Act. And these are really the foundation of the whole Act. So if you're doing any work in connection with the Act, you need to know what the conditions are. The conditions in Section 2, there are 4 of them, but what they come down to are, firstly, the person arrived irregularly. And what that means is they need leave to enter or some other form of leave, but they don't have it. It also means that they obtained leave by means of deception or by means which include deception. And what that's supposed to catch is people, asylum seekers in particular, who come over to the UK, stay on a student visa or some other form of visa, but actually intending to claim asylum. And they're also caught by the Section 2 conditions. So that's the first one, irregular entry. And the second one is indirect entry. So they don't come directly from a country where their life and liberty is threatened. So they pass through or they stop in another country. And if those two conditions are met, then a whole raft of things happens to them under the Illegal Migration Act. One of them is Section 5 of the Act, Section 5.2, states that any protection claim or any human rights claim involving a country of origin is inadmissible. And that's clearly going to apply to a very large number of asylum seekers. The UNHCR, for example, has said that the Section 2 conditions in practice will apply to the vast majority of asylum seekers, and it's right to do so. The Illegal Migration Act also expands the circumstances in which a claim will be declared inadmissible under Section 80 of the Nationality, Immigration and Asylum Act 2002. So already someone who comes from one of the safe states in Section 80AA the claim will tend to be declared inadmissible, but the safe states have been expanded, and there are a couple of other changes. So perhaps the most important is that the safe states now include Albania, which was the top nationality claiming asylum in the UK in 2022. So it not only expands the Section 2 condition circumstances in which a claim is inadmissible, it also touches on other applies to other cases. So the short point, there are going to be many more cases which concern failed asylum seekers, and therefore many more people shifted onto the Section 4 of the 1999 Act support. So there are also a number of provisions about victims of trafficking under the Illegal Migration Act. So the key provisions under the Act are as follows. So firstly, whether the Section 2 conditions are met and a positive reasonable grounds decision has been made, then there are three key consequences for victims of trafficking. Section 22 disapplies the prohibition on removal during the recovery period. And what that means in combination with the rest of the Act is that there's a duty to remove even a victim of trafficking for whom a positive reasonable grounds decision has been made, but no conclusive grounds decision has been made, so during the recovery period. The second consequence of the Section 2 conditions being satisfied is the requirement to grant leave is also disapplied. And the third consequence is that the duty in Section 50A of the Modern Slavery Act 2015 to secure the assistance and support is provided for asylum seekers, to victims of trafficking is also disapplied. There is an exception in the Act, which is essentially when the victim of trafficking is cooperating with a criminal investigation. But there are a couple of other criteria which are linked to that, which mean it's a relatively narrow exception. Now, many victims of trafficking, like asylum seekers, will satisfy the conditions in Section 2, so this will apply to many victims of trafficking. The question arises how to challenge all of this. These are just a few of the provisions of the Illegal Migration Act which are going to be open to challenge, or how to mitigate it. That is a very long answer, and in the next 3 minutes, which I have really to cover this point, I'm only going to be able to just very much touch on the surface. But just a couple of ways in which this can be challenged are as follows. Firstly, the Northern Ireland Human Rights Commission, who I represent, have been given permission in a judicial review challenge in Northern Ireland to argue, firstly, that in Northern Ireland, the Act is in breach of what used to be called the Northern Ireland Protocol, what's now called the Windsor Framework. And the essential argument is that EU law, so far as it was applicable up until Brexit, should remain applicable. Now in England, it is no longer applicable. The Illegal Migration Act takes precedence. But in Northern Ireland, you can use the Windsor Framework to argue that it should continue to be applicable. And that has pretty far-reaching implications in Northern Ireland, not here, unfortunately. But another way that you can try and challenge or mitigate the consequences of the Illegal Migration Act is using the European Convention on Human Rights. Now, of course, that's politically very controversial, but legally it's at least something that may be used. The ECHR, to give an example of how the ECHR may be breached by the Act, is Article 4, the protections concerning victims of trafficking, and a few aspects of Article 4 which are likely to be breached by the Act are as follows. Firstly, Article 4 probably requires there to be a conclusion reached on whether the individual is in fact a victim of trafficking, and also a conclusion reached in the investigation into credible allegations of victims of trafficking, of crimes of trafficking, and that conclusion should be reached before the victim is removed from the UK. Now, in many cases, the Illegal Migration Act will at least subject the Secretary of State to a duty to remove the victim of trafficking before those matters have come to a conclusion. Whether that removal duty can be complied with is another matter, but in a number of cases it will be. And so that's likely to breach Article 4 in certain cases. Another reason why it's likely to breach Article 4 is that Article 14 of ECAT, the European Convention Against Trafficking, which there's a good argument at least it is brought into law effectively through Article 4 of the European Convention on Human Rights. That requires a minimum level of support. That requires leave to be granted, including where the victim is pursuing an asylum or protection claim based on their fear of being re-trafficked. That's likely to be contrary to the prohibition in the Illegal Migration Act on granting leave in this sort of case. The third way in which Article 4 might be used is one which I was going to come to earlier, which is about assistance and support. So there's a good argument that Article 12 of ECAT is brought in through Article 4 of the European Convention. The Article 12 of ECAT requires support and assistance. The support and assistance that it requires is greater than the normal level of asylum support that you get under Section 95. And therefore, the part of the Illegal Migration Act which essentially cancels that duty to provide that support is contrary to Article 4 for that reason. So that's just a very quick run through the Illegal Migration Act. There are a few more aspects of it which I touched upon in my notes, but I don't think I've got time enough now to go into that, so I'll leave it there for now. And in the couple of remaining minutes that I have, just touch upon another piece of legislation, which is the Houses in Multiple Occupation Asylum-Seeker Accommodation (England) Regulations 2023. Now, this was something that was introduced much earlier in the year, but remains in draft form. The government have been threatening to bring it into force, but haven't quite got round to it. What it basically does is exempts houses in multiple occupation who house asylum seekers from the protections in Part 2 of the Housing Act 2004, which concern licenses for houses in multiple occupation. Now, the Part 2 regime in the Housing Act, the licensing regime for houses in multiple occupation, is really important. It's been recognised as such by case law, government guidance, a huge range of other authorities. For example, the case of Rogers and Islington noted that 4 of 10 houses in multiple occupation were unfit for human habitation. The chance of being killed or injured in a fire were 28 times higher than for residents of other dwellings. And the licensing regime was in place to try and tackle those sort of risks. So the fact that it's being withdrawn for asylum seekers is a real problem. Now, just briefly to give a couple of ideas as to how the regulations may be challenged, and permission has been granted in a judicial review case to challenge them. In paragraph 29 of my notes, I look at Article 14 of the European Convention on Human Rights, and partly as a means of just reminding everyone of a couple of important or useful bits of law as to Article 14 challenges in many areas. I've gone through the 4-stage test as to whether there's a breach of Article 14. So the first question, ambit, does the measure fall within the ambit of another convention right? And it's likely that these regulations at least fall within the ambit of Articles 8 and 2, so the right to privacy and the right to life, because of the impact that they're likely to have on individuals and the risk they're likely to put individuals to who are in HMOs. Article 3 may be a bit more difficult, but it's likely to fall within the ambit of those two rights. Second question, status. Is there a protected status involved? And the group adversely affected by the regulations is asylum seekers, and that is a recognised protected status for the purpose of Article 14. Third question, is there an analogous situation? So are the asylum seeking group in a relevantly similar situation to others who aren't subject to that detriment? And what's important in this context, and what may be very important in a challenge to the regulations, is that although there are obvious differences between asylum seekers on the one hand and others, for example, asylum seekers are accommodated under Section 95, others aren't, what one has to focus on when asking whether there's a relevantly similar situation is the purpose of the measure in question. And the purpose of the Part 2 of the Housing Act is to protect residents from fire and other dangers. Now, that purpose applies equally to asylum seekers as it does to anyone else who's in a housing multiple occupation. And so one could argue that because the purpose applies equally, then they are in relevantly similar situation. The fourth question for Article 14 is justification. Is any discrimination justified? I don't really have time to go in any more detail into this, but in my notes, I've identified a couple of the justifications put forward by the government and given reasons as to why those justifications are unlikely to be lawful. They're unlikely to be good justifications. In summary, the government hasn't put forward evidence to prove that what they say is the justification for the regulations is right, in particular that Part 2 prevents supply of HMOs, or there's a less onerous alternative. So the justification isn't sufficient because the government could have achieved what it's aiming for in a much less onerous way. I hope that quick rush through isn't too baffling, but I think I've come to the end of my time limit now, so I'll leave it there.
Thank you very much, Adam, and thanks to all our panelists for very interesting and informative sessions. I don't know if anyone's got any questions. I saw that James has posted some which have been answered by Shushin. So I'm going to open it up to everyone with a reminder to unmute yourself before you ask a question, or you can just type it in the chat if that's less intimidating. And I also wanted to just say that the notes from the presentations will be circulated via email, so don't worry if there's anything that you missed during the talks. In the absence of, or while we're waiting for questions from the audience, I had a particular question, which is, Kaz and Shushin, you both talked about litigation and needing to bring either successive claims to get policy and practice to comply, or the need for the court to make successive orders in order to enforce Home Office compliance. What can practitioners do to make sure that litigation in migrant support is as effective as possible? $1 million question. Shushin.
I'll go on, Shushin. Yeah, you go first.
I suggest that, Kaz, perhaps you could talk a little bit about how you worked with DPG to develop the series of litigation, because obviously you guys have brought quite a successive number of litigation to chip away at the various policies, under the same rubric of Nrpf. So it'd be interesting to know sort of how you went about gathering that evidence that informed the judgments.
I guess it feels like a very two-way process. We've been in touch with DPG, especially, as I said, Adam Hunt, since we first started. And at that point, so there was the challenge in 2014. And then, as I said, there was a few years when Adam was very aware of the possible challenges, but the lack of evidence base. So we were in touch about that from when we started. And I guess from the start could then be we as an organisation could be quite strategic and deliberate about what data and evidence we collected. And that then led to us publishing a research report that was very specifically targeted towards that legal challenge that then happened. So I guess that's how that kind of partnership started, and then from then it is a two-way thing of we, through our casework, notice trends, and obviously which we can then discuss as we go with DPG. So for example, the most recent litigation that happened, we were being increasingly contacted by people who had Nrpf but had visas, which meant they couldn't make change of conditions applications. So case by case, that's something that we would discuss with DPG up until the point where that was something that could be litigated about. So yeah, it's kind of a constant communication.
Can I add to that? Just in terms of some of the successful litigation, I mean, even thinking about, I didn't mention it and I should have done, but the sort of early years provision for families with no recourse to public funds that Claire Jennings and others had again done, that kind of progressively building the case for, you know, chipping away at different levels of entitlement and demonstrating that those within Nrpf and undocumented families should also be able to access that. I mean, I think the thing that Kaz speaks to, which is really important, is obviously having very strong relationships with the VCS organisations that have the evidence base and working collaboratively with them so that they can actually kind of orient their data collection and to help build the case for the things that are actually happening on the ground. Yeah, I think, you know, even just thinking about where there's been other legal challenges, successful ones that I've been involved in, so around access to legal aid for separated children. Similarly, it was working within a civil society NGO organisation with legal reps to be able to actually say, well, look, these are the sorts of cases that we have, here's the evidence base that's available to us, what are the possibilities with that? And as Kaz kind of speaks to, what's been really successful with Unity Project is doing that over the course of many years. And where we're kind of identifying those cases. I think also the thing that's really important for NGO organisations is obviously they're doing a lot of the firefighting, is they need that steer around what to look out for, what is going to be really beneficial, what sorts of cases are really helpful to highlight, because as far as they're concerned, so many of these cases are exceptional and difficult, and it's not possible, you know, just on their own to kind of see where the strategic opportunities lie.
I mean, I think that's definitely right, because certainly in the context of the NHS charging context, part of this litigation arose from a lot of the work that was done by Maternity Action and others on just NHS charging generally, and and gathering the evidence on the disproportionate effect of that on, particularly on women and pregnancy related treatments in the main, but also FGM, sexual violence. And then coming across women who eventually get leave, because Maternity Action does a lot of casework for immigration-related casework for individuals, and coming across them actually being detained and the debt coming back to haunt them over and over and over again. And I think from a lawyer's perspective, the difficulty with a lot of times with these cases individually is by the time the client presents a problem, it's a year out of time, or it's like 7 months ago, or whatever it is. And that certainly was a difficulty in the context of the undocumented migrants Section 3C challenge. And we've been looking for individuals to challenge that. But what is the time limit? Is it when they can't get access to work? Is it because they get a job suspension? Is it that they can't get a right to rent check quick enough to not lose an apartment, or whatever it is? So that's oftentimes the challenge. But the other challenge is, to pick up on Leonie's second part of the question, is remedy. So you win. How do you enforce the win? And I think the ECPAT challenge is quite unusual, because the judge was very proactive in managing the consequences of the judgment. I think probably because he tested he took the temperature in the room during the course of the argument, and probably was not confident that by doing a very lengthy, detailed, careful judgment that was sufficient. Because normally in judicial review, you have a judgment, you have an order, that's it. It's up to the public authorities to go and implement it and sort that out and reflect on it and act lawfully. Well, clearly we're sort of 4 months on, and we're still in a situation where there are various interim orders and directions for further action to be taken for the judge to be satisfied that actually he can bring the claim to an end. And that is unusual, but obviously good in this particular case, because otherwise I don't know, we'll just still have hotels housing unaccompanied children.
No, and a further question again to all of you. What do you think are if you had to pick sort of the top 3 most pressing issues that you can see in the near future, over the next year or so, in migrant support, what would you say those are?
Speaking to Nrpf specifically, so obviously the vast expansion of no recourse to public funds, so also and kind of temporary routes impacting asylum seekers as well. So a similar sort of system as the sort of 10-year route and applying Nrpf conditions to people's leaves. Although, yeah, there's still obviously measures that are to be brought in place. But the impact of that will be significant for already stretched support organisations and local authorities that already do not have adequate resource to meet the needs of these communities.
Just to reiterate the point I was saying earlier, I think the Illegal Migration Act, if it's brought in, because there is a question mark about that at the moment, and some suggestions, I think that the government is waiting to see what happens with the Rwanda litigation before seeing whether it is going to bring it in. But if it is brought in, then it will hugely expand the number of people who have to rely on Section 4 support rather than Section 95 support under the 1999 Act.
Susan?
Well, and following from Adam, increase of detention powers, increase of, use of barges and reception centres and the conditions in that. I'm not sure the government's trying to make people share rooms or trying to put these centres in the most remote areas necessarily, and having some fudge in terms of suitability criteria is really going to deter litigation around these issues, when it's quite horrific that, you look at Manston and what happened in Manston, and you read the sort of Strasbourg case law on Malta, and Malta being found in breach of Article 3, and Hungary being found in breach of Article 3 because of the conditions of reception centres there. And then you read what's happening in Manston, and it's sort of like, well, is this really actually happening here as well? So I think where do you even start is sort of a rhetorical question, really.
One claim at a time.
Sorry.
Kaz, did you want to add anything?
Well, no, I mean, I guess there's as Shushan said, there's a lot we could say. I guess one very specific thing is there is sort of one sort of, rather than a challenge, I guess, sort of a thing that feels kind of winnable in the shorter term is in relation to Nrpf, access to childcare for those with Nrpf, and there's an ongoing campaign to expand entitlement to childcare for those with Nrpf. So yeah, very specifically, something that maybe is a bit more winnable.
Sorry, one more. Can I really quickly add? And I think it was related to a point that Shushan was making. I know Kaz can speak to this, but I think it is a really important point to make around where does legal challenge go even when it's successful, because certainly on the Nrpf grounds, in terms of trying to actually get that change in guidance, etc., unfortunately the Home Office will try to as narrowly define it as possible, and actually so much of the struggle comes even after a successful case, which again I know Kaz can speak for length to that issue, because you not only are you waiting ages, but also at the point that there's a change made in the immigration rules or to guidance around whatever the issue is, it's so much of a battle to even get it to that point, which is why it's so important for legal reps to continue to work really closely actually with support organisations to make sure that that work happens, because it is quite a significant undertaking And yeah, I think sometimes the kind of momentum gets lost at that point as well.
There was just sort of more general strategic point to this type of JR public interest litigation that if I can bring that in, Leonie, if you don't mind. It's a slight segue, but I know we're right at the end, so hopefully this is of interest more generally. Which is that I'm involved in a case this week, which is challenging people who are brought to the UK under the Nrpf scheme, so the Afghan resettlement scheme. A number of people who granted eligibility under the scheme have gone to Pakistan or Iran or other countries, and then the Secretary of State has said, okay, we're not going to allow you into the UK until we've got accommodation for you. But obviously they don't have accommodation for everyone, so they're all stuck in Pakistan and Iran, and Pakistan are saying we're going to deport everyone back to Afghanistan, and they're in a pretty dire situation. But there's the case I'm in is a challenge to the Secretary of State's policy not to bring people over to the UK, and there's quite an interesting strategic point that came from it, which is that the Secretary of State refused to disclose evidence and really stonewalled for a sort of suspiciously long period of time. I think whenever that happens in a public law case, you've got to sort of really press them to give you something, because you know something's going on behind the scenes. And eventually, after various requests under Part 18 and so on, it came out that the Prime Minister had made a sort of back of an envelope policy decision: don't let any of them back in unless we've got housing. Sent it to someone in the Ministry of Defence. It somehow found its way backwards to the Home Secretary, but she wasn't consulted at the time. It sort of came to a civil servant through the back door. And all of this has to come out in the litigation, and they're basically on the edge of making a new decision about the whole policy, partly because they've hopefully been embarrassed enough into having to do so. But the main point is just, if you get some stonewalling like that, really push.
Thank you. Right, I think unless there's any questions from the audience, that concludes our seminar for tonight. I'd just say thank you very much to all our panelists for your talks, and thank you to everyone for coming on this extremely rainy and stormy night, albeit virtually, and for spending time with us. Thank you very much, and we hope to see you soon.
Thank you.